estate planning for about the next hour to an hour and a half, depending on questions. I have everyone muted now. I will open it up for questions towards the end, or you can always type a question in the chat. Feel free to do that. And the one thing and I will definitely address your questions if you have any. One thing I do want to do is make sure that you guys can hear me. So if someone can just type in the chat and say, yes, I can hear you, I can see your screen. The screen should have a sheet that says selecting and working with an estate planning attorney. So let me make sure that we have that. Thank you very much. Good, can hear me. So these are the questions that I put up here are the questions I would be asking an attorney if I was in the market for one, knowing what I know. Everyone asks about price. We'll definitely talk about fees and fee options, but there's about 13 other questions you should be asking the attorney, 13 or 14. And so I'll check back in towards the end of the discussion to see how I've done, and you'll at least know our answers to that and why we're asking those questions. Okay. And so that's kind of the little bit of the background, and I'll just get started. So I'm Bobby Fazy. I'm an estate and business planning attorney. Our practice, we have a team of 10. We've got 4 attorneys, 6 support team members, and that's what our focus is. I'd say 60 to 70% of our clients consist of estate planning clients, 30 to 40% on business. A lot of our clients are business owners too. And so we're not family law attorneys. We're not personal injury attorneys. This is our core competency. You'll find I'm a very blunt attorney. Most estate plans don't work. How would you know if your plan worked or not? Maybe when would you know might be a better question. And so let me see if I can move this up a little bit without losing the camera. Okay. It'd be when would you know might be a better question. And so a lot of people maybe have a plan or don't have a plan. They don't know really what's going to happen. I think the starting point when you think about estate planning is just think about how you want things to play out in your own mind, right? I call it the snapshot test. So visualize a time that after you've passed away, you're looking down from your cloud from above. All my clients look down. They don't look up, right? Beats the alternative. But the idea is if money's going the way you thought it'd be going and people doing what you thought they'd be doing, and that's generally a plan that worked. Money's not going where you thought it'd be going, people not doing what you thought they'd be doing, probably something that didn't work. And my goal today is to give you kind of a good, clear picture of that snapshot. I find there's a lot of kind of smoke screens out there. I find a typical planning trap is people just focus on the documents. The documents are important, and we'll definitely talk about documents and what they do, but they really are, that's short-sighted if you're just focusing on the documents with the attorney. My analogy is I'm a big fan of the show called The Fixer Uppers. If you've ever seen that show, it's a couple named Chip and Joanna, and Joanna they renovate houses. They come and sit down with the clients and they say, Joanna's like, what's your view? What's your goals here? How do you want the kitchen to look and feel? And then Chip is the carpenter, and he comes in. And my analogy from that, or when you renovate a house, is the analogy on the estate planning front is, does anybody ever ask Chip, right, the carpenter, what tools he's using? No, they want the end result. I want the kitchen to look like this and feel like this. And so that's the same thing when it comes to estate planning. The documents are just the lawyer's tools, right? Which one is working for you depends on your specific situation, your goals, and how your family picture looks like. There's some consistent tools that are used, but it's not like a one size kind of fit all, or and so that's to me is kind of short-sighted on that, is that the documents aren't going to do the work when someone passes away, right? It's family, it's money, that's what their people are dealing with. And so we got to figure out how are we going to get through that? What's the process? Another trap is just focusing on taxes. I don't have a big estate, so I don't have any estate tax issues, so I don't need to do any planning. That's short-sighted too on a couple of fronts. Tax planning is not as big of an issue, you're right, from an estate tax side anymore. If it is an issue for you, good for you. It's the current estate tax exemption on the federal level is almost $13 million. That's 12,920,000. But that exemption number keeps changing, and it's going to change. It's scheduled to change in 2026, down to about 6.5 million. That still may not be an issue for you, right? But did you know that there's a legislation that will impact all retirement plans? Well, retirement plans, how does that impact my estate? Well, when you leave your beneficiary designation on your IRA or your 401k, what's the tax impact on that when you pass away? What happens, right? And so those things get changed by legislation, and there's nuances that maybe you do have a tax, but you just don't know, right? And so that's the issue there is don't be short-sighted on the tax side of things. And then the transfer trap is just focusing on, hey, I just want to avoid the probate process after death or the court process. And probate is just basically a government audit of your affairs after you pass away. It is completely avoidable. And I'll show you how you can do that with no legal documents. So you can leave today. If that's your only goal, I'll show you how to do it, and you don't even need an attorney. And so there you go. I'm hoping you'll see that there's more other issues that you may be missing, but that's what I find typical traps are. And so I find what's really missing is knowing all your options, getting with someone that's familiar with your situation, and making concrete recommendations for you. I just find that people don't know their options. And so their snapshot might look a little bit like this, fuzzy. Again, I'll make that focus today, or I hope to make that focus. And the way I start with that is you should, if I'm working with an attorney, I would ask them how they define estate planning. Okay. I'll show you my definition of estate planning. It's not just my definition. It's the National Network of Estate Planning Attorneys definition. I like it. It's really stood the test of time. It covers all the issues, but it makes you understand what estate planning is about. Okay. And so number one is, yeah, I want to control my property while I'm alive and well. Never had a client have an issue with that. Then a plan for me and my loved ones if I become disabled, mental disability. So estate planning is not just death planning. Hopefully you never become mentally disabled or have a disability. But if you don't plan for it, it can be really tough, okay? Not only for you, but for the family as well. So control while healthy, a plan for disability. And then I want to give what I have to whom I want, when I want, in the way that I want. And I find people don't know all their options there, okay? All while assuring my wisdom is transferred along with the rest of my wealth. So I try to set the bar high, right? It's not just about moving the material wealth. If we can capture some non-material wealth, hey, this is the place to do it. This slide here is talking about this planning pyramid is really, it's our counseling philosophy. So I'm sharing that with you. This is how we work with clients is we just work towards the base of the pyramid and work our way up. So the first part of the whole process is getting to know what your goals, hopes, fears, and concerns are. And then we look at the family. Are you married or not? If you're married, do you have kids? If you have kids, are they minor children or adult children? Whole host of different issues for minor children than you would have for adult children. For minor children, we're worried about where the kid's going to reside, where the guardian's going to be, how does the money work on that end? And for adult children, age doesn't necessarily equal experience, and so they may not be ready for the money, or maybe there's a special health need or concern that we have there, or maybe how are their marriages if they're married, strong, shaky, are there creditor concerns on that end, how do they get along with one another? And so every family dynamic is different, but once I understand the goals and the family structure and dynamics, then we can present some different options on preserving wealth, expanding wealth, and saving taxes. Okay, and that's the kind of the progression of the planning is start with the base, work your way up, and the idea is you teach us the family, we'll teach you the law. Together, we'll make the plan work. Okay. Here's 4 keys to an effective estate plan. Every time I get asked to review a plan, these are the things I check off. One is personalized counseling. Did this person get good personalized counseling, or is this some word processing that they could have got off LegalZoom? I'm going to show you some examples of the differences. And you maybe that is what you need, is just a document right now. But I find that the counseling side of it is definitely much more valuable and effective, and it just depends on where you are in life on that. The next common issue or key issue from an estate planning side is proper asset ownership, okay? There's only 3 ways you can own your assets: in your individual name, jointly, and by contract. That's it, okay? And so big part of estate planning is making sure you get a great set of instructions and making sure your assets are actually aligned or titled the way so that it's going to be the least amount of hassle, most amount of protection, least amount of taxes as possible, right? Number 3 is then have a formal review process. Things change, and I'll show you how we address that. And then the controlled transfer process, right? We want to, is there a controlled transfer process? And you probably, maybe not, you may not have verbalized it, but that's probably one of the main reasons why you're here. Is if you didn't care, if you didn't care how things kind of played out, then you wouldn't, then you don't really try to plan for this. But let's get blunt. What if something happened to you today, right? You died today. How prepared is your family if something happens today? And what I mean is, would they know what to do, how to do it, and how to pay for it? And I find people are not really, they don't know what to do. Something happens, a death occurs, they're at the mercy of the attorney, or they don't know even where the attorney is at. And so they can't find the legal documents. So that's the issues that I see that we'll address. The 5 areas that I find here is these are the different areas or different options and ways to plan. One is you can do no documents. That is not a good way to do the planning. Well, I'll go over that and give you those options. You can do what's called a will and a POA. POA stands for power of attorney. Okay. And so there's 2 different types of categories of powers of attorneys. There's what's called a financial power of attorney. And then there's a medical power of attorney. And as the name implies, the financial one is where you're designating an agent to make decisions for you, financial decisions for you as a financial power of attorney. And that's number 1. The other one is to make healthcare decisions for you. Okay. Now, within the power of attorney framework, there's a couple of subcategories, a couple of flavors of that. And so you can have what's called a general durable financial power of attorney. And so that is one that is effective right when you sign it. And the other type of financial power of attorney is a limited financial power of attorney, which is only takes legal effect only after you've been determined to be disabled. So you see the difference between the 2? Okay, one's effective immediately, one's only after you've been determined to be disabled. The healthcare power of attorney, or some jurisdictions will call it an advanced medical directive, that's designating a healthcare agent to make healthcare decisions for you. And that's only kicks in when you can't communicate with the doctors. Okay, so that's what that POA is. It's an acronym, but that's what that means. Okay, so you would get a financial power of attorney and a healthcare power of attorney, and you would get what's called a will. And if you go with that type of planning, then and I'll go into a later slide, but a will basically that's if you want the family to go through the probate process, do the legal work at the end and let them deal with it. Okay. And then you have the will with a testamentary trust and power of attorney that will also cause a court probate after death. A testamentary trust, so stay with me, a last will and testament. A testamentary trust is one that's created after death. Okay. I don't know why you would do that and have court oversight over it, but sometimes people will do that. And then there's what's called a simple trust. I think these are the kinds that you can get pulled off of the web or the internet. Not much counseling, just, hey, here's my name, my address, and here's a document. I'm not a big believer in that approach. I'm more on the modern approach side. Whatever documents that are needed to do the plan, and we'll get those, we'll put that as part of the plan. And typically we'll have a trust component, we'll have powers of attorney, so we'll have a combination. But the key is that there's a process. We get the notification something has happened. Hey, there's a death. Everything's in good order. Just be with the family. When you're ready to talk about the legal side, here's the next steps. This is what you need to do. So we've got it all laid out, right? Not where's this document? What does the document say? And so that's what I find is out there, and every family is different, but those are the 5 options in the planning. The challenges in the estate planning world are, one is mental disability. I think that's probably the biggest challenge today. And to be blunt, when you're disabled, right? versus the death, you're still here. So there's a whole host of issues like, where are you going to be? What type of care are you getting? What's the level of care? Where's the money coming from to facilitate it? So a lot harder to deal with mental disability planning. Then asset transfers on death. What happens to the assets? They were in somebody's name and associated with somebody's social security number. What happened? How do I get control over it? What happens, right? What's the taxation side of things? How does that work? And then your personal planning goals. Yeah, I want to make sure that the assets are protected. If my kids get divorced, I want my money to stay with them, not any ex-spouses, or I don't want it to be spent down for Medicaid purposes. Whatever your goals are, those are the challenges that we see in the estate planning world. Our approach to this is not the only approach out there, but I like this approach. It's a 3-step approach where we're setting up the plan, we're maintaining it, and then we're there for the settlement. Okay. And so we're looking at the whole picture because we are expecting to be there. And so I call it an empowered design. And that's when you develop the plan with counseling oriented planning partners. And what I mean by counseling oriented is that they're going to sit down with you and go over your options. And make sure you understand your options. And then partners is if you have a trusted advisor in the family, a financial advisor, a CPA or like, we'll work with them. Okay. My goal is to make sure that the plan works and that having those people involved and integrated, it makes things go easier typically. Empowering the legacy is just maintaining the plan. And so I'll show you what's involved with our maintenance plan. We have a maintenance plan. It's optional, but I'll show you what's involved with that so that when something does happen, we can empower that inheritance. We can secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So we're setting up the plan, we're maintaining it, and then we're settling it after the death. The typical, let me give you a little bit of education. So I'll teach you about how titling works in the estate planning world. And title is really critical. When you think about estate planning, we're being able to manage the transition of wealth from one person or one generation, from one name to the other. How do you do that, right? And so that is, you need some of the basics and knowledge. So the first one is, a lot of my clients are engineers. So anything you own in your individual name at death, that's going to be, that equals like if you had the will, you did the will as your main centerpiece of your plan, and that would equal probate. Okay. So think about your assets. If you have anything in your individual name, that's going to go through the probate process. Now, the how you can avoid that probate process without doing any legal documents is you can title everything as, you can do different titling options. Okay. And again, I don't recommend this, but you need, sometimes that they do fit in the specific situation. So one way to avoid probate is to title assets as joint tenancy with right of survivorship. The way that works is that when one owner of the asset dies, the asset will go by operation of law to the surviving owner. You bring the death certificate down to the bank. Like most people are familiar with that. Okay. But let's play this out in the real world, because I've seen enough of these play out where, let's say it's a husband and wife couple and one spouse passes away. Okay. So, and I always have the husbands check out first in my plans. It's just statistics. You can do whatever you want, right, in your plans. But let's say husband passes away. Now everything is in wife's name. We avoided probate on the first death. Okay. Let's say they have 2 kids. So everything is in wife's individual name. So now everything is now going to go through the probate process. So we're asking the surviving spouse while they're grieving to figure out how to get everything set up for the kids or even for themselves at that point. Why don't we just figure it out up front and do it right the first time? And if you think you're just going to add the kids to the accounts or to the deeds of the like, well, think again, because that is putting on a lot of liability, right? Because when you put anybody else's name on an asset, you're taking all their baggage too. So if they have a divorce or they have a creditor, or if they want to take the money, they can. So it's not a very good approach to it. And there's some tax implications as well. The other type of a way to do it is you can title assets with a transfer on death designation or payable on death designations. These are the financial institutions documents, and they're written in fine print. I don't like their contracts on their side, but it basically says this asset will go to this person on death. And in certain circumstances, we will employ that approach, okay? But it's not a one size fit all. And then planning with the box, and I put box in quotes. That is if you are familiar with, and most of my clients are, IRAs, 401ks, anything with a beneficiary designation, right? That's going to avoid the probate process probably, as long as you write the right name in the beneficiary designation. And there's a lot of different options there, okay? And the new law called the Secure Act has impacted all retirement plans. And so these are nuances. And when you designate a beneficiary, it's usually a lot of wealth that's being transferred. Wouldn't you want to make sure, yeah, that's the right option I chose, right? So that's important. And then the what I find is that is a short-sighted approach of just avoiding probate. You're missing what the real planning goals are, and these are typical planning goals for the clients. Is number one is disability planning, remarriage protection, creditor protection, divorce protection, values promotion. So what does all that mean? So one of the primary goals for a lot of our clients is they want to address disability planning. And so if you did have that big illness towards the end of your life, stroke, Alzheimer's, right, dementia, do you have an opinion if you'd rather be taken care of at home or in a nursing home, or you don't care? Right. And if you have an opinion, where in your legal documents does it say it? And most people think that they've done their disability plan because they have what's called the healthcare power of attorney or the advanced medical directive. And that is a legal document. It's important, but it just designates an agent and it gives them a list of powers. It says you can check me into a hospital, you can check me into a nursing home, you can bring me home and give me home care, you decide. And so my point is, if it's that important to you, let's put it in there. If it's not important to you, you're not doing your family any favors, okay? My dad had dementia, and the first few years, he was still kind of with it, but years 7, 8, and 9 was really tough. And I think that he may have wanted to go into some higher level facility than be at home and be a burden on my mom. But we don't know that because we never went through those issues with him. And so that is the point, is it's not just the legal document, but it's this counseling that goes behind it and laying out the options and making sure that the family or whoever the people are that are helping know what their role is and know the game plan. Okay. And so that main thing is, wouldn't you rather leave instructions for your own care? And another big issue is when you no longer can control your finances. Hopefully it never happens to you. But again, there was that point with my dad when he was sending money to the wrong people. And so that's a really delicate conversation to give up control of the finances. And the key is that I found in our experience is it's better to have a process on how you give up control, right? So the ideal thing is for the clients to be able to say, hey, I'm disabled now, but you're disabled, so you can't make that decision. So the next best thing I can do for you is I can give you control on how you would give up control, if that makes sense, okay? And then this is the approach that we use. I ask 3 critical questions when we do the design. When am I disabled? Who do I trust managing my money when I'm disabled? And what can they use the money for? Okay. And when am I disabled is the timing, right? And it's not when just 2 doctors anywhere in the world say I'm disabled. That's a component. A doctor should be a part of it. But maybe if you're married, maybe a doctor and a spouse, or if you have family members or friends that could be part of that discussion because they know you best. And you can have a second medical opinion or not. So we call that a disability panel. And once they trigger it, then yes, at that point, yes, I'm no longer able to manage my affairs. We can pass those assets or pass control over those assets to the next person in line. Here are the instructions. We're not going through court. We're not going through a bunch of litigation or getting red tape by different financial institutions. We got a strong process to get through that. Some people are worried about a catastrophic illness where they have to go into a nursing home and spending all the money of all their wealth. And there is one payer of long-term care services. It is Medicaid. But Medicaid is a government agency. It's administered through the states. But you have to be basically penniless before they will pick up the tab. And so that's not a good place to be, but through trust, you can qualify. That's beyond this discussion here. I just wanted to make sure I address that in the disability planning side. That is an option. Second is remarriage protection. Not a big deal between the spouses of a husband and wife situation, but it's usually about trusting the new person. So my favorite cast of characters, let's say Bill and Mary Sample, husband and wife, and they have 2 kids. And let's say they have the I love you wills. The I love you will is a very common strategy where Bill will leave all of his assets to Mary if he predeceases her. And then when she passes, everything goes equally to the kids, right? And the vice versa. Mary could leave everything to Bill if she predeceases and then goes to the kids. Very common. So let's knock off Bill and everything goes to Mary. And let's say Mary meets Bo the tennis pro, right? And they fall in love and they get remarried. So we're talking about remarriage protection. And let's say that Mary dies before Bo, okay? But Mary's will says everything goes down to my 2 kids. Even though her will says everything goes to her 2 kids, does Bo, the new spouse, have a legal right to those assets? Absolutely, in all 50 states. And so it just depends on what state and length of marriage, but it could be anywhere from 1/3 to 1/2 of the estate. Okay, another key teaching point here is, if you are taking notes, is title trumps the legal documents. So what that means is the way assets are titled will override like the will or the trust or the other legal documents. So let's say most married couples own their bank accounts jointly, joint with right of survivorship, right? And so if we are a married situation in a second marriage and they title their accounts jointly, it's not going down through the will to the kids, it's going to the surviving owner, the surviving spouse. Who's usually the beneficiary of an IRA? Remember planning with the box? You're filling out that beneficiary designation form. The custodian of the IRA does not go to the will. They just look at the beneficiary. Oh, you name the spouse gets the money. So if there was a way that Bill could leave his assets to Mary and Mary could use it for whatever she wanted, but when she passed, it had to go down to the kids. Is that something that's worth spending some time talking about? Counseling or word processing? If it's not important to you, at least we got to check it off and go through it, right? And so the important thing is that we're reviewing those issues. Creditor protection is another common goal for a lot of our clients. And I think there's a lot of misunderstandings with creditor protection. I'll tell you my school bus story, and I'll use myself in the example on the school bus story to explain creditor protection. Okay, so let's say that I've passed away. And there's 2 assumptions in the story, forgive me. 2 assumptions. One is there's no creditor protection for me while I'm alive. And number 2 assumption is I'm dead in the story. Okay, so let's say I passed away, and let's say I'm married, and let's say I leave everything to my spouse and my kids. And so let's say there's a couple different ways I could, well, let's play it out a little bit. So in the story, let's say my spouse is all distraught after I pass away, runs a red light, bam, hits a school bus full of kids. Horrible facts, right? We got a killed school children, not enough money in my estate or insurance I can do to pay it. It's a catastrophic creditor. So there's a couple different ways I could have left my assets to my loved ones. It doesn't have to be a spouse, it can be anybody. I'm just using spouse as an example. And I'm going to show you through the scenario. So number 1 way is I can leave everything to my spouse in a simple will. I die, everything goes to my spouse. She hits the school bus, there's creditors. Everything that she received through my will, gone. Those are subject to her creditors. Secondly, is I could have titled everything jointly with right of survivorship, with bank accounts and the like. Remember I told you about that. It avoids probate, but when the surviving owner, when all those assets go into the surviving owner's name, they hit the bus, all those assets are fair game. If I own the house jointly, bank accounts, any of that stuff can be attached. Thirdly is by contract. Let's say I have a life insurance policy. It's not worth a lot when I'm alive, but let's say it turns into $1 million when I die. I get that $1 million. I put that when I die, she gets the $1 million. She puts it in her account. She hits the school bus, gone. Okay. Fourth way is by a simple trust. I was telling you, I review these a lot. They're on, you can download those, but there's very little counseling. And it says, when I die, everything goes outright. Same problem, okay? And I'll go through how to fix that. But one of the, let me do my planning again. Let's say I pull myself out of the grave and I could have done my planning differently. What if I did it this way? What if I could have left my assets to my loved ones? They could use it for whatever they want, but if they hit the school bus, it's protected from their later creditors. Let me say that one again, because that's important. This is where we talk about asset protection. They can leave the asset, I can leave my assets to them. They can use it for what they want, but that they hit the school bus, it's protected from their creditors. So how many of you would like to leave your assets to your loved ones that way, protected from their later creditors, right? And how many of you have ever been asked that question before? Is that counseling? Is that word processing? Did you know you had that option, right? I'm trying to focus that picture for you. You don't have to do it. I'm just showing you this is, and most of our clients like that. And the way that you do that, okay, just briefly on the asset side, is you do use a trust, but I find there's a lot of misinformation on trust. So think about this Yeti as a revocable trust. And a revocable trust means I can change it, I can revoke it, I can amend it. And it's just an open cup where I can get in and out of this cup and use the assets for whatever I want, but my creditors can as well too. So this is not, a revocable trust is not going to protect me. Remember that story, the assumption is I have no creditor protection. But when I die, I can put the lid on it and say, this is my hard-earned wealth for my beneficiaries. They can access it, but my money is not to be used for their creditors or for their ex-spouses. With their money, you can do with what you want. This is my money, I'm leaving to them. Very powerful legal strategy there. And that's how you can do that, okay? You can give them the key, but not other people. And that's a very, we call those school bus trusts. Our clients call those school bus trusts, but that's an important feature on the asset protection side. The other issue that we commonly run into is the divorce protection, and I don't spend too much time on this one. How would you like to assure that the assets that you leave to your beneficiaries stays with them? Okay, and so that is one option. And then values promotion is, I call this my babysitter story. So I got started late in life. I have now she's going to be seven-year-old next month, 7-year-old daughter. And so if you, many of you have kids or ever had a babysitter, the baby, usually when you're trying to go out for your first relaxing evening for a dinner and a show, right? You're interviewing the babysitter, you're telling them all the things that you need to do. Hey, she's going to want to stay up late. If you read a book to her, read every page, because if you skip a page, she knows. I don't know how she knows. She's not going to want to brush her teeth. Our neighbor's information is here, will be here. And so the idea is we have all these instructions and we're just going away for one evening, right? So would you agree that we leave more instructions for our loved ones when they're little and we're only going away for one evening for a dinner and a show than we even think about leaving in our estate plans when we're going away for a lifetime? And it's not something where I'm going to give you a blank piece of paper and say, give me your values. There's certain places in the plan where it could be appropriate. And so my goal in telling you this is I'm trying to show you, kind of give you a glimpse in the design of the plan. And so it's almost like going to the eye doctor where we're going to narrow down the options for you and but lay out your options so that you know what they are. And then, so that's the first step. That's what I find is, and that's how we work with our clients, is that first step is really important. And then we have a maintenance plan. And the maintenance plan is committing yourself and your family to a continuum maintenance and education program. So how does that look like? And the best way I can explain it is, and before, early on in my career, I would focus on the, hey, you need to update your plan and maintain it. And I think people get that. They just don't want to pay the attorney. Once we get the plan set up, they don't want to pay. I was like, okay, let's focus on the fees and focus on the services. And so we offer a maintenance plan. It's optional, and it's $995 a year, $995 a year. What do you get for that? I'm not going to nickel and dime you for phone calls, emails, and faxes. You got a question? We're not going to bill you for that. We're not going to nickel and dime you for that. Hey, you want to make a change and it's just a word processing change, someone moves, some name change, you want to change the order of stuff, that's a word processing amendment. That's part of the deal too. Plan should be kept updated. This next one is probably the most important one, and it's probably worth the money in itself. It's called annual funding double check and ongoing funding support. That is a lot written in the what does that mean? And that's important that you understand what that means. And so let me show you what that means. So funding in the estate planning world means that you created a revocable trust and you've actually put your assets inside of the trust. Okay, and people say, what does that mean? I didn't come up with the term funding, but it's really just re-registering or retitling your assets into the name of the trust, so that the key is if everything is connected in the trust in some way, and there's different ways you can connect it to the trust, okay, that when major life events happen, disability and death, we can just pass that trust to the next person in line, sidestep the court system and the like. There's still work to be done, but it centralizes management of the assets, the control and instructions clear, and you can really build in those protections. So most estate plans fail. I see a lot of people have trust. I ask them, is it funded? Funded means that we have the assets titled in the name of the trust. So every one of our clients gets an asset report, and every year we're going to update it. Check mark means, yep, we verified it's in Williams, and we live in a world of acronyms. I'm sorry, Revocable Living Trust. It's verified. And every year you're going to give us the new values, or if you sold something, you're going to cross it out. And if you bought something new, you're going to add it. And so I'm looking at the report. We're looking at every year. Why don't we have the beneficiary designations confirmed, right? And so that's the key on the administration, is that we have everything in place. So you have to have the assets in the right place. And I find most people don't even make it to that level. And so that's really important. And so that's what I mean by annual funding double check. You'll get that on your portal, that report. And if you're going to buy something new or sell something, let us help you on doing that. Okay. There's a family meeting, no additional charge as part of the deal, as long as it's done within 6 months of signing the plan. And the goal for that is I want to make sure that it's optional. I can't force you guys to have a family meeting, but the goal would be that the people know what to do, who they are, know the law firm. Because again, all of these things come from, I want the plan to work. Okay. It's not about how I can bill an extra. It's that I want the plan to work at the end. And this is how we get there. Okay. And this is how we found, rather than hourly billing, this service is able to do that. We've done over 50 administrations. So we've already handled 50 death administrations. And so we've learned a few things along the way. Group document updates. So every 3 years, our clients get new legal documents to comply with the latest laws and different techniques. There are also changes in their personal situation. So we use a report called an estate planning review worksheet. It's a very important tool. And it's a quick way for you to make changes, or let us know about your personal situation. No change here. I want to change here. I don't want to change here. And you submit that to us or upload it on your portal. We have group educational programs throughout the year on different topics. The one that's most attended in my firm is the one that we do the Saturday before Thanksgiving. My clients call it the 911 program. I call it the nuts and bolts one. It is basically what to do when a loved one becomes disabled, what to do when a loved one passes away. So my client advisory board said, hey, why don't we put a big required training for them? And so I do a live program every year, but if you don't make the live program, then we've got the video backup. The key for me is that they get the education. That's one of them. Like on the Secure Act with the IRAs, I'll probably do a specific program on that. There's some technical issues that are still being developed on that. DocuBank membership, that means online medical directive. So you're typically not going to be carrying your medical directive in your back pocket if you get into, an accident or have to go to the hospital. But what our clients have is a card. I'll show you how the card looks like. And you can access your directives 365 days a year, 24 hours a day, anywhere in the world, right? And that's basically laying out the medical directive, right? Or if you have medical snapshot, this is not a legal document, but the snapshot is, here's my healthcare providers or my medical conditions or surgeries or my medication list, if you're on different medications and the like. And so the idea there, and then you can just print the documents, or they can be emailed or faxed directly to the healthcare provider and it's done very quickly. Okay. And so there you go with regard to that. So it's the practical aspects of the planning as well. And I think that was the last one on the maintenance side. Let me make sure. No, I think I got a couple more. Enrollment in digital assets, executive services, and maintenance. So all your digital assets, okay? And that's not just crypto, but crypto is a big area if you do have cryptocurrency. But other assets, like if you have a website or Amazon accounts or photos, how do you want those dealt with? Or emails, they can all be lost if you don't have. And so we just learned through the, through the settlements, you have to have these things buttoned up, and it makes things go a lot smoother. So that's our maintenance plan. It just lays out those services, and we find with that base level of services, we're able to maintain the relationship, and we're familiar with the family, and they're familiar with the law firm as well. It makes things go smoother. So that when something does happen, so set the plan up, maintain it, to secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. Okay, so that's the third step, and we're looking at the whole picture. So what happens? How do you secure appropriate assistance, Bobby? And for my clients, it's about cost, controlling costs. So we're definitely talking about fees now, how we structure ours, and how generally they're structured. So how you control costs in the estate planning world, okay? What I've learned and what I've seen is, number one is full funding is one way to control costs. What does that mean? That means if you created a trust, you put everything that possibly could go into the trust in the trust. And I don't want you to leave here thinking everything has to go in the trust. So there are some major exceptions. Like, you're not going to put your retirement plan into your trust. That's a contract, a retirement plan. They're going to avoid the probate. We're going to look at the beneficiary designation. So funding that retirement plan is by making sure we get the right beneficiary designation on that account. And why that control costs is if I have the right, everything titled the right, and I don't have to go to court, it doesn't mean that there's no work to be done. Okay, I'm sorry. Death is a major life event. Everything's got to be wound up, but it's not on we're not on the court schedule. It makes my job easier, and we're doing things in the back office side of things. Okay. The second way to control costs is proactive trustee and beneficiary training. Like I told you, I don't want to be educating a surviving spouse or the kids after the death, because that's during the grieving process and things aren't sinking in, and it's not a good time to be educating on that. So I'm trying to educate them beforehand, not making an expert, but they know the basic process, what to do, so it is an easier transition. And then we have a proactive engagement approach where if you are on our maintenance plan, we'll agree to administer the trust at predetermined rates. Your family does not have to use us. Your successors don't have to, they have to affirmatively hire us. I can't ethically bind them, although our clients would like me to ethically bind them. But everyone does use us typically when we do the administrations. They'll hire us for that. So that's how you control the cost, full funding, get the people educated that need to know what to do. We have a proactive engagement approach here. Here's the ceiling on the fees there. And so let me go into how those fees are structured now. I already talked about funding, and this is just a visual. We want to put all of your assets in the trust. So full disclosure of the cost. So the sets of the costs that are out there in the estate planning world is the cost of the initial counseling and the documents and setup. And I think most people are just focused on that. They don't realize they're missing the boat. The other factors are updating your plan, or most people fail to update it, and then the costs after death, which are usually people get blindsided from that. So let's start with the cost after death. I'm a big Stephen Covey fan. He said, proceed with the end in mind, right? So let's look at death. Let's look at the death fees, and no one looks at these, but I'm the guy who does that. So let me show you. This is Fairfax. This is in Virginia. Every state and jurisdiction has their fee schedules, but they're all pretty much similar. I'm going to show you a couple of flavors so you get an idea of how they structure them. This is Virginia. This is if you want a will and you're saying probate's fine, okay? And so these are the fee schedules that are published. You can go check in the courthouse. These are what reasonable compensation is for the fiduciary. And so typically they'll name a family member as the executor of the will, and they don't know what they're doing. They hire an attorney, and the attorney will charge rates commensurate here, or they need to be within these guidelines or they're going to be in trouble. Okay. And what this is saying is, I love that. It's in quotes. It's a reasonable compensation state, Virginia. And this is what's reasonable. While the assets are tied up in probate, 5% of the income receipts. So income receipts, right, are rents. If you bring in rents or interest income payments or dividend payments, right? And if you bring in $100,000, right, then 5,000 of that is 5%. I'm making sure I get that right. And so that is a reasonable fee on that side of things. Yeah. It's not 5,000, it's not 50,000. No, it's 5,000. Okay. And then the principal shows you how much my math skills are. I'm an attorney. And then if you had $1 million go through probate, okay, that was just the income. If you had $1 million go through probate, so then the first 400,000, they could charge 5% on that. The next 300,000, 4%, the next 3%. So you can see how it's done on a percentage scale. And so that's like 40 grand that can be charged on $1 million estate. Now, do all attorneys charge this? No. Some will charge less, some will charge more, but it just depends. I find that they're going to charge as much as they can. And so it depends on how out of whack the estate is and how unorganized it is. And so this paragraph back here says the commissioner who's in charge of the compensation can increase it or decrease it in exceptional circumstances. Factors to be considered. It's just rational, logical things, right? The nature of the assets. Is it a business? Is it real estate? Is it an IRA? The character of the work, the difficulties encountered, the time and expertise required. And that's where they usually put the fee in higher. Okay. Loudoun County is the same as Fairfax. It's just Fairfax had a nicer thing. Here's Maryland. If you live in Montgomery County, Maryland is at 3.6%. So you got to find their fine print. So if the property subject to administration is over 20,000, the commission may not exceed more than 1,800 plus 3.6% of everything over 20,000, right? That's what the attorney can charge. That's if you go through the probate. Now I put these Florida statutes as part of your packet in here to teach you about trust administration, okay? A lot of people make this mistake. And I put Florida, let me back up. Florida is one of the few states that has put actually put a law out there that put a cap on what an attorneys can charge to do a trust administration. So you said, Bobby, you got me. It makes sense. The trust makes a lot of sense. Let's do it. But when someone dies, right, there's no work to be done, right? No, there is going to be work. And that's what this is talking about. This is what I'm trying to teach you, is that Florida has a lot of seniors that move down there. It has a very strong senior lobby. Would you agree? Like some people joke about it. They call it God's waiting room. And so they have a lot of people who are older there. And so there's a lot of trust plans that are out there. And there's a lot of trust attorneys. And then they finally put a statute, the legislature, because they wanted to put a cap on what attorneys could charge to do these administrations. Okay. And paragraph number 3 is what that's saying. I'll just boil it down for you. The attorney could charge 75% of what they could have charged on a normal probate to do a trust administration, okay? And so the 2 teaching points are, number 1, when you die, whether you do a will or a trust, there still needs to be a transfer of the wealth, okay? And then you have to wind up all of your affairs. Think about how many usernames and passwords you have. That's just that, okay? Everything, and you have to let the IRS know. Okay, every one of your relationships have to be closed. So there's going to be an administration. It's just with the will, you've got to go report to the court every time. And there's certain things that you have to do with it. With the trust, you can keep it all private as long as you do it right. Okay, and so that's the number 1 teaching point, is that there's work to be done. Number 2, because Florida has such a strong senior lobby, it gives you an idea of what, hey, this is what the market rate is for what attorneys charge to do a trust administration. Like, for the will and the probate and what attorneys charge for probates, those are public records. They have to file that with the court. Go look at there. And I gave you the ranges. The trusts are private, and so those are harder to find. But this gives you an idea. This is Florida is more of a consumer protection state. So they're saying, hey, between $1 million and $3 million, their percentages are lower than Virginia and Maryland. They're at 2.5%, right? Versus 5 or 4 or 3. But that's 75% of that number is what they can charge. So you get a 25% discount, but you see the numbers are still at those percentages. Okay. Probably more than you ever wanted to know. But I wanted to show you how it works. Our fee schedules are like this. There's a setup fee, maintenance, and after death. Option 1 and option 2. Option 1, I'll start with the administration fees or the fees at death, and that's only if we're hired is when that would be would be charged. And so we cap our administration fee at 1.25% on the size of the net estate, right? You just saw 5, 4, 3%. We're going to be lower, like 50% than those schedules because of this maintenance plan, right? It just makes sense. If I have a fully funded trust and I don't have to go through the court process, that makes my job easier, and that should translate into a cost savings for the client. If I have an educated family that knew what to do, followed the process, which we've done, okay, over 50 times, that makes my job easier, and that translates into a cost savings. If I have updated legal documents, right, that are up compliant with the latest laws and your goals, makes my job easier. If you have a financial advisor or trusted advisor that can set up the inherited IRA accounts, or we can work in tandem in the back offices, that makes my job easier. So that makes sense, and people get that, and that's where the $995 comes in a year. Optional. And then for the first year to set up to enroll in our maintenance plan is a little bit additional fee for that. It's $1,500. That's to get you set up on DocuBank with those online directives, to get you set up with your digital executor services with the DCS, get you set up on your portal. So that's your setup on all that on the maintenance. For the cost of the setup of the trust and the plan and funding the trust and the like, we charge 0.5% on the size of your net estate, subject to a minimum of $5,000, a maximum of $13,500. Where you land on that depends on your goals, your assets, and the like. Nothing gets charged until you know exactly what you're doing. I'm just giving you ranges here. If that option 1 is too high for you, option 2 is 1/3 of 1% on the size of your net estate. Our maximum there is $8,500, and the minimum is still at $5,000. But the back end, we charge more. We'll charge 2%. I don't care which option you take. I just want to make sure you understand that we're not competing with LegalZoom or any of the firms out there that are just doing the documents. We're doing the documents. We're doing the counseling. We're putting everything in the plan to make sure all the assets are integrated, which is the time-consuming, tedious part. And then we're getting you set up. So the heavy lifting is up front, but then you're just on maintenance, okay? That's how we set our fees. This is how my practice is set up. People ask me, hey, Bobby, what if something happens to you? I've got more clients worried about my health and welfare than I've ever had in my life. We've got about 300 families on our maintenance plan. We've got a team of 10 here. And so I would not be a good estate planning attorney if I did not have a good succession plan in place. So my succession plan is really driven by the business model, which I'm showing you, is that we have relationships with the clients and we have residuals coming in to support that. And so our team is growing. I have an internal succession plan. I have an external succession plan right now. And it's with Ed Clay. We have an agreement where, and his bio should be in your packets. He's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his. And he teaches with me at the national network. So I'm very comfortable with his teaching style, and he can run the practice now. And until I have my internal succession plan fully developed. So I think I got about 3 to 5 years from that. We've got some junior associates that need some time, but they're getting to that point where we can get that documented. So that is my succession plan. I'm not going anywhere, but I want to make sure. I see so many attorneys that are in the estate planning world, they die, the clients don't know where to go. They didn't tell their clients who to go to from that. That's not going to happen with us. And then on the maintenance and education side of that, That, those every year, the relationship gets tightened with the families, the client families, the team gets to know the families, and it really is a client family. And we get referrals from our existing clients, which are great. It means we're doing the right thing. And so it is not a profit center for us. You're getting a lot more value than that $9.95, just by doing that funding report every year. But that keeps the relationship, and it does make sense because the settlements go smoother and we know the family and they're referring. So that is good. And then our initial counseling fee is not just doing documents and trying to get you in and out as quickly as possible. We want to do this right. Let's get the counseling right. Let's do the documents to support the plan, and let's make sure everything is titled right as well. So we're not looking for 600 clients this year. My goal is 60 clients. Okay, we do less clients, better, more work, customized work, and it's a relationship-based approach is our approach to the planning. So that's our fees structure on that. Yeah, this is the question that I would ask the attorney is, okay, this is what you cost up front. What are the rest of the fees? And what's the rest of the story? If you ever, I'm dating myself, I was a Paul Harvey fan. He's a radio disc jockey or announcer, and he would always say, what's the rest of the story? So I'd ask the attorney, what's the rest of the fees that you charge? How much do you charge for trust settlement administration? And if they say they can't tell you, you say, these are my assets. I die tomorrow. What are you going to charge my family? And you probably won't like the answer. The disability and death side, right? So then the death tax return preparation, like our goal is not nickel and diming. That's part of the administration. We're going to handle that. And then this is a trick question for a trust attorney. I would say, how many of your trust-based plans wind up having probate? Okay, and you charge differently for those assets, right? And so if there's an attorney creating trusts, but none of the assets are going through the trust, they're all going through probate, that's a red flag, and it's going to be a mess on the administration, okay? Because nothing's been titled right. If you're going to go with the trust, you got to do the follow-up work and do the titling. And so generally the fee kind of discussion, traditional probate, I showed you, those are anywhere, cost after death of about 2.5% to 5%. The standard living trust planning with that Florida, giving you kind of the Florida market rate with a 25% discount is like 2% to 4%. Ours is about 1% to 2% for the entire life of the plan. And so it's not something where I'm competing on price. It's just something that works and is done because we maintain it. Okay, so that's full disclosure of our fees generally. Hopefully that'll give you true peace of mind. At least from our side of it, we know exactly what we're doing in the scope of the work on that side. So traditional planning versus the modern approach. Traditional planning, you get your basic documents and questions answered, but the modern approach is so much more. And I think we're living in a time and age where people are demanding more. And so you've got the counseling, you've got the funding, the maintenance, surviving spouse support, settlements, disability events. So we're there for that. The next step on our side would be, if you are interested in exploring further, is you would request a discovery meeting. And so that is right here, as far as the steps. Right here is where we're at. It's an hour meeting, right? It's been about an hour, give or take. And that's no charge, goes over our process, philosophy, and fees. The next meeting would be a discovery meeting. Michelle would coordinate, and that would be with one of our associate attorneys, and that would be with Zoom. And they would review your personal information form, do a short goal setting exercise, and then give you a fee range. The initial interview is with me. I'll go over scope of engagement, specific fee quote. I use my stop sign there is because there's no fees charged until we both decide to work together. And so that's the level of the work. This is what we would do. Do we want to work together? If yes, we do that, then we begin the design of the plan, the design meeting. That's with me. We'll go over, remember that trip to the eye doctor. We'll go over your various options. That can last anywhere from 2 to 4 hours. I would never keep you more than 2 hours in the meeting, and they can be done through Zoom or live, whichever your preference is. And then there's a delivery and review meeting. Oh, my little chart doubled up there. Sorry about that. So then the delivery and review meeting is where you we review the legal documents, make sure you understand it, answer any questions that you have. And then let me fix this. Hold on a second. And if anybody has any questions, feel free to ask them. Okay, so after the delivery and review meeting, that's where we review the documents, legal, make them legal, sign, witness, notarize. That's typically going to be a trust-based plan with medical directives, powers of attorneys, and funding everything. You will have a will, but the will is called a pour over will. It's a backup to the trust. Attorneys call it a pour over will. It sounds nice. I think I call it the legal pooper scooper. It cleans up after your mess. The pour over will says it lists your trust as the beneficiary. So if you left anything out of your trust during your lifetime that should have gone in there, the pour over will scoop it and pour it into the trust. It sounds good, but anything that's left out of the trust goes through probate. So you're going through additional administration. Why not? You don't even need to do that if it was in the trust, okay? So there's the delivery and review, and then we're not done, okay? We're not just doing documents. We're going to look at your financial assets, your financial plan, and make sure that the financial plan and the estate plan are coordinated. And if you have a financial advisor or a trusted advisor, that's great. They would be at that meeting. They can come to any of the meetings, but that's one that's specific for that. And we want to make sure we have an accurate inventory of the assets. We have a plan for each asset. Once everyone says, yep, this is what we want to do, then we have the funding meeting where we manage that process. Our funding coordinator, Ginny Oliver, will have all the magic forms to get everything in the right place, deeds, financial forms, and the like. And then there's an optional family meeting, no additional charge as long as it's done within 6 months. And then you're just on maintenance. And I get a lot of people asking, wait, when can I get my documents in my hand? If you are motivated, then these meetings, I like to do them about every 2 weeks to keep the process moving. If you are really motivating, this meeting could be consolidated to one meeting. It just depends on how quick you need it, but you can usually get your documents within 6 to 8 weeks. And then we begin the funding aspect of the plan. All right, so let me see how I did with my questions that I posed at the beginning, and then I'll look to see if there's any questions in the chat before we conclude here. So I would be asking, if I was in the market for an attorney, I would ask them with their background, experience in the planning field, what percentage of your practice is in estate planning? Ours is about 60 to 70%. So the point of that is that's our focus. We're not just dabbling in this. And how do you define estate planning? If you remember, I want to control my property while I'm alive and well, a plan for me and my loved ones if I become disabled, and I want to give what I have to whom I want, when I want, in the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. And then what's your counseling philosophy? Ours is, if you remember that pyramid, let's get to know your specific situation and the family dynamics, then present options, not just say, here's a strategy without knowing you. What's your process for working with me to assure that my plan will work? I'm a big believer, process produces predictable results. I see it in action. And so you saw our process chart, and it's very predictable on that side. How will you counsel with me to design my plan? I'm hoping you get some of the insight from my side. I usually tell stories, use visuals to communicate these legal concepts. I can go deeper if we want to, but most people say, no, thank you for, for not going that deep with that. How do we assure that my assets are controlled by my instructions contained in my planning documents? Right? This is a big question to ask, okay? This is a big fee question. Who's responsible for this? You or me? Is that in your fee or not? Right? Because that is a big deal, all your assets, okay? How do we assure that my plan stays current with changes in the law? That's our maintenance plan. What's the level of involvement of my family in the planning process? I think more involvement is better, but I know family dynamics, every family is different. And then how do you charge for services? Specifically, how much will my estate be charged after I'm gone? Right? I showed you that probably ad nauseum. What if I'm disabled? And so because of our maintenance plan and disability process, it's very discounted on the disability side of items. If living trust attorney, here's that trick question. What is your record with regard to probate? What percentage of your trust-based plans wind up having assets probated? Do you charge differently for these assets? Okay, this is all fee questions. Do you handle the filing? And these are, we have only gone through one on ours, and that was because of a German asset that wasn't disclosed. And so I was very upset with my perfect probate record, but the idea of it is we're not going through those. And if it is, and if it's on us that's something that you disclose to us, then we will honor that. Okay. But it's typically we're not being told that issue that of that asset. Do you handle the filing the death tax returns if they're necessary? Yes, that's part of our fee. And it become more and more of a prevalent to file tax returns, even if you don't have a taxable estate. I didn't get into this today, but there's something called portability, which is a estate tax exemption that you can only do by filing the tax return. And it protects the surviving spouse or the kids, actually. What happens if something happens to you? That's my succession plan, right? How do I prepare for our consultation? That would be going through the personal information form. What type of service should I expect from you? So I'm a big believer in team. I told you we have a team of 10 and growing. And so you're going to be working with different people on the team, but you'll be working, with me on the counseling side. You'll be working with Ginny on the funding or Taylor on the funding side of things. Michelle get you coordinated and set up on portals and things like that. So everyone's got their own role here, and you get better service that way. Do you expect any commitments from me? Yeah, I mean, fill out your personal information form. Think about your planning goals. My goal today was to get you thinking about issues you might not have thought about before, and think about which ones are most important for you to address. The helper roles, who will fulfill the necessary helper roles, are your backups, okay? This is one thing you can't do on your own. If you die, you can't settle your own estate, right? Or disabled, there's different issues. So think about candidates. Our job here is to say you pick the right one or not, or give you options. Do I have a current inventory of assets? Since it's a big part of estate planning is knowing where all the assets are. So that's really important. And then what advisors can I involve in the planning process to more effectively design and implement my plan? If you have a financial advisor, that helps. It's not a requirement. And CPAs as well are good. Am I willing to meet the commitments asked of me? So basically for us is just respect our process, our time, and we really, once we get involved in a project, we're going full steam ahead. So with that being said, I will conclude. If there's no questions, I'll check to see if there's any questions or not. I will shut down. So I'll hang out for about a minute or so, and then I will go. Thank you very much for your time. Hopefully you guys got some good information today. It's been Bobby Fazy, president of Insight Law, discussing estate planning and estate planning options. Thank you. So I got some questions. Does life insurance payout counts to the assets calculated 1/2 or 1/3 fees? No, I don't count life insurance. And so some attorneys do, but I don't. And so that does not count towards I just look at your net worth. Will I receive a copy of this recording? I will have Michelle, if you reach out to Michelle and ask for a copy, feel free. She will send it to you. Be happy to do that. How do you protect my personal, how do you protect my personal information? So good question. So we, obviously as an estate planning attorney, I have sensitive information. And so we pay a lot of money as far as encrypting our servers. And I have an IT department that I pay a lot of money. So it's above my pay grade on the encryption type. And so we don't have loose files around. A lot of it is digital, and we have a portal. And so, yes, that is very important to us. And I'd be happy to let you talk to our tech department on that. But yeah, we take that very seriously. So good question. Anything else before I conclude? Thank you. All right, everybody. Have a good weekend. Thank you very much. Talk to you later.